Your book.
All right. Welcome. Today is October 7th, and we're here for a special hearing for two cases. Brandon, will you call order?
Yes. Board Member Crow.
Present.
Board Member Little.
Present.
Board Member Sis.
I'm present.
Thank you. That completes the roll call.
Okay. Everybody stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America
And to the republic for which it stands,
one nation, under God,
indivisible, with liberty and justice for all.
Please remain standing. I will place everybody under oath that will be addressing the board today. You will need to be under oath to address the board. When I complete reading your oath, please state I do. Please raise your right arm. You and each of you to solemnly affirm that the testimony you're about to give and the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you. You may now be seated.
Okay, so next would be the agenda review.
Yes, item 5, agenda review for October 7th, 2019. The clerk of the board recommends approval of the agenda review by the Assessment Appeals Board. The agenda review consists of the following agenda items. Item 9, application number 1810414, applicant Jeffrey Ganter, continue to December 9th, 2019, pending receipt of the original stipulation. Item numbers 10 through 11, application numbers 1810874 and 1810876, applicant Sam's Real Estate BSNS Trust, removed from the agenda due to the submission of a withdrawal. Item number 26, application number 1811245, applicant Ryan Neely, denied due to lack of appearance. Item number 27, application number 1811252, applicant Ventura Retail 5 LLC, removed from the agenda due to submission of a withdrawal. Item number 29, application number 1811370, applicant Tad Dwyer, denied due to lack of appearance. Item numbers 30 through 31, application number 1811474 and 1811475, applicant Skyworks Solutions Incorporated, removed from the agenda due to the submission of a withdrawal. Item number 32, application number 1811477, applicant KDF Citrus Tree LP, continued to December 9th, 2019, pending receipt of the original stipulation. That completes the agenda review. No one has checked in for these items, and recommended action is to approve.
Looking for a motion to approve.
So moved.
I'll second that motion.
Thank you.
All right, and please vote using your computer terminals. There we go. All right, thank you.
Okay. Are there any comments from the public at this time? Any comments from the board at this time? No. Okay. All right. On to our first item. Application 17-10905 Air 7 LLC.
Mr. Broge, if you want to come up to the podium.
Good morning.
Good morning.
Could you state your name for us, please?
Gregory Broge of Ashulat, Poly, Abe, and Matarisi. My last name is spelled Broege.
Okay. And are you prepared to move forward today?
Yes.
Okay. But how long will your presentation take?
Not very long, 20
Okay.
minutes.
Okay.
And real quickly, I discussed this with Mr. Broge beforehand. He's not the representative authorized when the application was filed, but he is an attorney, and therefore, just Mr. Broge can confirm that the taxpayer has authorized his appearance here on their behalf in lieu of the original agent on file, which was Arlex Tax Service.
Okay.
Yes, I was actually here for the first phase of this hearing on the CITUS issue, and the taxpayer Air 7 has authorized me to proceed with this appeal.
Okay. Thank you. Assessor's Office?
Yes, good morning, Christopher Horn for the Assessor's Office. We are ready to move forward as well. We estimate about 15 minutes.
Okay. Okay, we're going to go through the rest of the agenda, and we'll come back to your case first.
Thank you very much.
Thank you. Okay, 18-10414, Jeffrey Ganter.
That has been resolved on agenda review. I would believe we are at item number 12 now.
Oh, excellent, yeah, sorry. Application 18-10926, Christine Sanchez.
No one has checked in for this item. Attempts to contact the applicant prior to today's hearing were unsuccessful. Recommended action is to deny due to lack of appearance.
Looking for a motion to deny.
So moved. I'll second that motion.
Thank you.
And please vote. Thank you.
Okay, next application 18-11112 through 11124, Sherwood Country Club.
Hello, good morning. Wes Nichols for the applicant.
All right, are you prepared to move forward today?
Yes, I am.
Okay, about how long will your presentation take?
My presentation will take about an hour to 2 hours.
Okay. And the assessor's office?
The assessor's office isn't ready to move forward, and we are requesting a continuance today.
Okay.
I would object with that. The assessor's already been granted their one-time postponed continuance. There was a formal 1606 exchange done. We provided many mounds of evidence, and we're prepared to go forward. I came all the way from San Diego today. I have the applicant's controller here taking off work today. We're prepared to go forward.
Okay.
Mr. Chair, I believe this discussion will take longer than a few minutes, and I recommend we come back to it after the other case, either after we've completed the remainder of the agenda or after the first case has been heard, depending on your board's preference. But this conversation is probably going to take a while.
Okay. Okay, we will come back to this probably before we start the cases, after we do the agenda review.
Thank you.
Okay, thank you. Next application.
Is he, if you want to come forward?
18-11307, Hewang Incorporated.
Is he? Yes, if you want to come forward to the podium.
Hi,
Hi, good morning. Can you say your name for the record, please?
my name is Helen He.
Okay, Helen, all right. And are you prepared to move forward today?
Yes, I already talked with my priest, so probably I didn't deliver all the document he request. Maybe,
Yeah, it's my understanding you wanted more time to discuss with the assessor how to proceed with your case,
Yes.
correct? And
Yes.
need to reschedule to a later day.
Okay,
Okay.
assessor's office.
It's this office's understanding as well that a continuance is in order because we're just receiving the information from the applicant today.
Okay,
So
okay, so we'll continue. Do we have a
Yes.
date on the calendar in mind?
The first date we have available is December 9th, 2019, or we have February 10th, 2020, depending on your preference.
either day for me.
Either one's okay?
Yeah.
Assessor, you have an opinion on the date?
the assessor has no opinion. If the clerk of the board would prefer it to be earlier, we can do December.
All right. Is there any requests for data exchange on this?
At this moment, not having reviewed the documents that came in, I'm going to ask for a proviso of 30 days just in case there's any additional information.
Okay. So we're looking for a motion to postpone to December 9th with the proviso that the assessor's office be provided any data they requested within 30 days.
So moved. I will second that motion.
Thank you very much. All right, we're all set. You can communicate with the assessor's office, and hopefully you guys can work this out.
So-
Thank you
okay,
very much.
So we've selected December 9th is when your hearing will be, but you have 30 days to work with the assessor to get them any more documentation that they need.
Okay, I will that before that.
Yeah, so just work with Josh and he'll be able to.
No, it's on.
Okay, thank you.
One more
you.
vote, please.
I messed up the whole thing first. Okay.
Any one more vote on that?
Yeah, you're right.
You want to vote?
Thank you, and that motion has passed. And then for items, I'd recommend we cover the administrative items as well, item 33 and 35.
Okay.
Item 33 is receive and file findings of fact. This is a little weird. They were issued by another set of board members who isn't here today, so it's they have approved and reviewed, approved, and issued them, and we're just asking you to receive and file them for the record. So if you just would make a motion to receive and file.
Looking for a motion to receive and file.
So moved. I'll second that motion.
Thank you very much.
All right, and vote, please. All right. And then we just have those regular stipulation agreements. I believe there were over 60 since our last hearing in July. Recommended action, if you've had a chance to review, is to approve them.
Yes, I've received them via email. And I did notice on a couple of them, there was some nice thank yous to the assessor's office. So that's nice to see that the assessor's office is working really well with the public.
We're doing the best we can, especially in the months where the board's allowed to take a break. We're not holding back. We're trying to push forward and get as many of these appeals taken care of. So apologies, Mr. Sisk, if your hand cramped up.
I had to break it in half. Okay.
Do we have a second to that motion?
I do have a question on one of the steps, the one about the mobile estates. Is that a mobile home park?
Oh, yes, it is. It's land value, or it's land that was, in essence, bequeathed to the mobile home park from the city, and we end up having to do an escape assessment on it. So we ended up adding that value into the existing value.
Well, it looks like it, the way the step reads it, you lowered the values almost a third.
The original value that was put on was appraised using comparable land that, in our opinion, in the appeals section, wasn't really applicable. This was more of spite strip land, and using regular commercial land required too much of an adjustment. So working with spite strip comparables, we were able to come to a cleaner value, and that's the reason for the reduction.
Okay. Yes.
Okay. I second.
Yeah, I have to see it.
Do we have a second to the motion?
I second.
Okay. And please vote.
Oh.
All right, and the stipulations are approved. That completes our agenda. We just have the 2 items remaining.
What do you recommend we hear first? Air 7?
It's up to you. I think the discussion on the continuance could probably take an hour, and the penalty discussion could probably also take an hour. So toss a coin, whatever you want to do.
Should we just go in order?
Yes.
And make that way? Okay. All right, Air 7 LLC.
All right, Mr. Broge, if you want to take a seat, or you're free to stand at the podium. It's up to you. Findings? Okay. Originally, no findings of fact have been requested on this item. Mr. Horn, still no findings of fact?
I'm sorry?
No findings of fact on Air 7?
That's my understanding.
Okay. And Mr. Broge is not requesting findings of fact, so no findings of fact on this item.
Excellent.
Yeah.
How many copies do you need?
Case one. About its location of the plane.
Yeah.
Room date.
I'm just going to give them all to you right now, if that's all right. That's one of them.
Board, I recommend we take a brief 5-minute recess while we get the applicant's exhibits handed out. That way we can start with them in front of you.
We'll do 5-minute recess. Okay, we are back on record and ready to hear the Air 7 LLC case.
Yes, and just to update the board, this is a bifurcated hearing. This is the second part. A prior board panel decided that this aircraft was taxable in Ventura County for the 2017 year. The second part of the hearing is to deal with the valuation and penalty of the aircraft, but the applicant has indicated they are no longer challenging value. They are only challenging imposition of the penalty, so that is the sole remaining issue in this application for your board to decide today, as whether or not the penalty should be abated on this aircraft for the 2017 year.
Okay, and who has the burden of proof?
The assessor starts with the burden of proof to show that the penalty was properly imposed, and the assessor's exhibit A has been submitted to your board.
Okay, ready when you guys are.
Good morning, Brooke Hill representing the assessor's office. I do want to clarify that while the assessor does have the burden for establishing the basis for the imposition of the penalty, at that point the burden would then shift to the applicant to establish reasonable cause for the abatement of the penalty.
Okay.
So this is an aircraft property statement. The applicant failed to file BOE Form 577 aircraft property statement as required by Revenue and Taxation Code 5367 and 5365 by the January 31st, 2017 deadline. The aircraft property statement wasn't actually filed or signed, by the applicant's attorney until May 7th of 2017 and was not received by the assessor until May 12th of 2017. So if I could have you turn to page 9. The assessor mailed the cover letter you see and then the aircraft property statement on the subsequent pages on December 2nd, 2016, well in advance of the January 31st, 2017 deadline. You'll note that in the first paragraph of the letter, we very clearly state in bold print that a 10% penalty will be applied if the attached statement is not returned timely. In the fourth paragraph, we reiterate that failure to file the statement will result in the addition of a penalty. And then you'll see on page 10 in the upper left-hand corner, you'll see the due date of January 31st, 2017. It says file return by, and then the due date. And then if I could have you turn to page 13. This is actually the applicant's exhibit. This is the aircraft property statement as received by the applicant, and it was submitted as evidence for the CITUS hearing several months ago. So they clearly did receive the property statement. And then if you can turn to page 16, this is what was actually submitted by the applicant's attorney, Vicki Baladian. It was received by the assessor. You can see the date stamp in the upper right-hand corner. It was received on May 12th of 2017, several months after the deadline. And on page 17, you'll see that Ms. Baladian signed it on May 7th of 2017, again, several months after the deadline. So at the point when Ms. Baladian filled this statement out, she had every belief that this aircraft was situated in Camarillo, and in fact reported on page 16, you'll see it circled that the aircraft location was reported as the Camarillo Airport Air 7 hangar. So if you could turn to page 23, I'd like to cover the underlying law that requires that they fill this statement out and the deadline on which they should file. So Page 23 is Revenue and Taxation Code Section 5365, which requires that upon request of the assessor of the county in which an aircraft is habitually based, the owner shall file with the assessor a statement that provides information necessary to ascertain the full value of the aircraft. On page 24, you'll see a printout of Section 5367. And this section provides that the statement requested pursuant to 5365 must be filed by the time specified by the assessor. And in this case, that date was January 31st of 2017. And it goes on to talk about the abatement of the penalty and says in order to abate the penalty, the applicant needs to establish to the satisfaction of the Assessment Appeals Board both of the following factors: that the late filing was due to reasonable cause and that the late filing was not due to willful neglect. So if you could flip back a couple pages to page 19, I'd like to cover the case law regarding reasonable cause, as I believe the applicant will be requesting today that you abate the penalty due to reasonable cause. The assessor disagrees. The assessor has not found any reasonable cause for abatement of this penalty. On page 19, this is a law summary that is actually put out by the Franchise Tax Board that deals with reasonable cause abatement. So they list several points here. I'd like to go over just the first couple that are very relevant to this case. The first on page 19, it's number 1. The burden of proof is on the taxpayer to establish reasonable cause for abatement of either penalty. And then number 2, the taxpayer has the responsibility to file the return. And that first paragraph under number 2 is important. Even if the taxpayer is unaware of a filing requirement, ignorance of the law is not an excuse for failing to file a timely return. And then that last paragraph I'd like to highlight as well. A taxpayer's reliance on an agent, such as an accountant or tax attorney, to file the return by the due date to respond on the taxpayer's behalf to a notice or demand from the FTB and or to reply to a request is not reasonable cause. And that's from a court case, United States versus Boyle, which we'll go over in a little more detail in a few minutes. And then the third one I'd like to just highlight is number 3 on page 20, that difficulty in obtaining information or documents needed to file the return is also not reasonable cause. So if you could turn to page 25. This is a copy of the decision for the United States versus Boyle case. I'd like to highlight just a few things here for you. At the bottom of page 35, they held that the failure to make a timely filing of a tax return is not excused by the taxpayer's reliance on an agent, and such reliance is not reasonable cause. On page 26, that first highlighted section, that the attorney as respondent's agent was expected to attend to the matter does not relieve the principal of his duty to meet the deadline. And then if you could turn to page 28. In the second highlighted section there, to escape the penalty, the taxpayer bears the heavy burden of proving both 1, that the failure did not result from willful neglect, and 2, that the failure was due to reasonable cause. And then if you could turn to page 29. I believe in the prior hearing, the applicant stated that they were unaware that the deadline was January 1st, 2017, despite having received the form timely. And so I would like to highlight this section here, the second highlighted portion, that they found that deadlines are inherently arbitrary. Fixed dates, however, are often essential to accomplish necessary results. The government has millions of taxpayers to monitor, and our system of self-assessment in the initial calculation of a tax simply cannot work on any basis other than one of strict filing standards. Any less rigid standard would risk encouraging a lax attitude towards filing dates. So just to summarize for you a little bit, the aircraft property statement, we sent it in early December. They received it. They self-reported that the aircraft was situated in Camarillo, which would require that they file with us as we requested. Their attorney didn't bother to return the form until May 7th, 2017, several months after the January 31st deadline. And so, you know, our case is pretty simple. I hope that I have laid out the law here for you, that this is clear, that they should have filed and they didn't file timely, and therefore the penalty should be sustained. I'm happy to answer any questions that you might have.
Okay, any questions from the board?
None.
No. Okay, any questions from the applicant of the assessor's presentation?
No.
Okay. You may take the stand and state your case.
Thank you.
Applicant's Exhibit 1 has been submitted for the record.
Do you all have it in front of you? All right, so there's no basic disagreement as to the facts of the case. Is a disagreement on some interpretations and what happened. Remember, we're not trying to find out who's right or wrong. We're just determining whether or not there was reasonable cause for not filing the return. Before I get into the law, and actually I think almost every exhibit except for maybe one or two of the four I gave out are actually in the assessor's materials as well. Before I get into that, I just want to give a little background. We already had a hearing on the situs issue. The major issue was whether or not the aircraft had situs for the 2017 tax year. This aircraft, and no one disagrees, this is undisputed facts, left California and left Ventura County in December of 2016, prior to the January 1, 2017 lien date, and never returned to California. So it was the position of the applicant that they were not habitually situated here. That was the issue in the situs case that went previously, I think in June is when we went forward. So here we're trying to determine whether or not there was reasonable cause for the applicant to not file the property tax statement by the deadline. So if you look at Exhibit 1, and this was also cited in the assessor's materials, this is the rule that says, the law, that says that the applicant has to file a statement with the county. And in the first clause, it says, upon request of the assessor of the county, there's no doubt that the request was received. We don't dispute that. You see that in the record. In which an aircraft is habitually based. That's the highlighted portion. It should be highlighted in the materials that are handed out. The owner shall file a property tax statement. I won't read the rest to you. The key here is in the county in which the aircraft was habitually based, otherwise known as situs. You only have the filing requirement if you have situs in the county. Now, no, we're not here to argue whether or not the aircraft was sitused in California. That was done at a prior board hearing and may go up to the courts. We're just here to determine whether it was reasonable for the applicant to believe that the property was not situs tier and therefore did not have a filing requirement. And this isn't an ignorance of the law type of thing. This is a question of the law. There's a case, and it was submitted as evidence in the situs hearing. It's called Brockby Board of Supervisors. It's a California Supreme Court case. In that case, people own jewelry. And what they used to do, the lien date used to be March 1st. They used to take the property, go to Hawaii before the lien date, then come back after the lien date and say, oh, we're not taxable. We weren't here on the lien date. And the court said, nope, you were only temporarily gone. You still are taxable because you're permanently based here in California. Temporary leave doesn't get rid of situs. But then what they did say in that case was, however, had they permanently removed the jewelry from California prior to the lien date, they would not have been taxable here. This is a case from the 1930s. It was 80 years old. So what the applicant did was, hey, our aircraft left prior to the lien date. We never came back. We have no intention of coming back. What we want to do is sell the aircraft. This was all entered into evidence in the situs hearing under penalty of perjury. That's a pretty reasonable position, I think, for not determining whether to file and for not filing. Because remember, you only have the requirement to file if you're habitually situated here. They took the position they were not habitually situated and did not have to file. Now, the next exhibit, Exhibit B, are we numbers or letters, Brendan? Sorry.
Numbers.
Numbers, okay. So number 2 is 5367. This was put in also by the assessor. The highlighted portion shows in order for the board to abate the penalty, you need to think that the failure to file was due to reasonable cause and not willful neglect. That's obviously what we're discussing. The next exhibit, Exhibit 3, is Section 441. This is the general property tax statement for personal property and fixtures that shows the various deadlines to file by. And I'm not arguing that this is the binding statute. The binding statute is clearly 5365. But I do want to point out that most counties, for their aircraft, follow the deadlines in 441. And if you'll notice in subdivision B, right before the highlighted portion, the due date is April 1st. For 441D responses. And so for most aircraft in most counties, your response date is 441D. Is April 1st. And so if you look at the assessor's exhibit, page 9 is the letter. Right? That's the letter that the assessor sends out. Notice that nowhere on this letter does it say January 31st is the deadline. 2, they do actually reference Section 441D at the bottom. So it is a little confusing because they keep saying due date and they reference Section 441D at the bottom. You don't see the January 31st due date until the tiny little thing on the top of page 10, file returned by January 31st, 2017. In most counties, that would say April 1st, 2017. However, you notice in Exhibit 3, Subdivision B, it says the penalty only applies if you don't file it by May 7th. So most of these tax preparers are aware that there's a due date, but then there's a later penalty date. As long as you file by April 7th, even though you're after the due date, there's no penalty. And so a lot of people might see that January 31st deadline and think, well, that's just the due date, but not the penalty date. And again, on page 9, no reference to the due date, and they actually do reference Section 441. Again, we're not arguing that the date wasn't January 31st. That's what the assessor put on. We're just trying to argue reasonable cause here. So it's not who's right or wrong, it's just whether there was reasonable cause. And I want to clear up something because I think there was a bit of a misstatement during the assessor's portion. They testified that Ms. Beladian, she's the taxpayer's attorney and representative who files all their property tax statements for Air 7. They have multiple aircraft. She referenced that Ms. Baladian had every reason to believe that the aircraft was situated in Camarillo. That goes counter to Ms. Baladian's testimony at the last hearing under oath. Ms. Baladian basically testified, we're at what she thought was the deadline, May 7th, and she hadn't reviewed the Air 7's flight records yet, so she just filed what she called a protective filing before she figured out whether or not she actually thought the property was situs in Ventura. Now, obviously, she filed it May 7th, which would have been timely in most counties, not timely in Ventura County. We're not debating that. But she wasn't admitting that it had situs here. She testified under oath. She just didn't know at the time and was getting it out the door. Now, the assessor presentation puts in a lot of case law from the Franchise Tax Board and from the IRS on what's reasonable cause and willful neglect. Well, I think the reason they did that is the reason I don't have other cases is there's no case law on it for property tax, and so they looked in other places. But remember, what's reasonable can be different depending on the taxes. Everyone knows when their income taxes are due. It's a widely known, I mean, you can ask my eight-year-old, he knows that income taxes are due April 15th. Everyone knows that they have income taxes due every year, right? That's just a known document. So what's reasonable for income taxes is not necessarily also reasonable for the filing of a property tax statement with the county when your aircraft left and never returned to the county prior to the lien date and during the tax year in which you're filing for. So what I did is, since there was a lack of case law on the topic, the only case law really out there was on failure to pay, and all of those, they just looked at what was for the ordinary course of business. They weren't really looking at reasonable cause or willful neglect. I went to Black's Law Dictionary just to see what the definitions were. So this is Exhibit 4. So the first page is reasonable cause. They say, see probable cause. So the second page is probable cause. I ignored the criminal portion of it and went to the tort portion. A reasonable belief in the existence of facts on which a claim is based and the legal validity of the claim itself. Doesn't mean you're right or wrong. It's just a reasonable belief based upon the facts in the claim. Well, in this situation, the taxpayer had a reasonable belief that its aircraft, which left the county and never returned, and left the state and never returned prior to January 1/17, and never returned at all during the tax year, July 1/17 to June 30th, 18, at least under the ownership of Air 7 LLC. That's a pretty reasonable belief based upon a 1930s California Supreme Court case that has gone unchallenged for 80 years. Pretty reasonable belief that you don't have a filing requirement. Because remember, you only have a filing requirement if you were habitually situated here. I think that's a reasonable belief. Next is willful neglect, page 3. They just say, see neglect. And it's basically omission or proper attention to the thing, whether inadvertent, negligent, willful, act of condition. I don't think the taxpayer willfully neglected, knowing that they had an obligation to file, and said, you know what? We do have an obligation to file, and we're not going to file. That's willful neglect. Their position was, we don't have an obligation to file. We're not situs here. If we're not situs here, there's no obligation. That's right in the law. Now, their tax agent, later in the year, up against the deadline, just filed what she called under oath a protective claim. Does not change the fact that there was reasonable cause for the taxpayer to not file this when their aircraft was not located in the county. That's my position. I reserve some time. I guess that's it for me. Thank you very much.
Okay. Any questions of the applicant from the assessor's office?
No questions, but we do have a rebuttal.
Of course, yes. Any questions from the assessors or the board? Sorry.
I have a couple. To the applicant. Does Air 7 LLC own other aircraft that they file on?
They do own other aircraft that they do file on.
And are they located in Ventura County?
One of their locations is in Ventura County, yes. They have a location in Oregon, and at the time, they may have had a location in Texas at the time as well. I don't think they have it anymore, but they had a couple locations.
Okay, so on the assessor's exhibit on page 16, where you stated that the applicant signed this as a protective filing, quote-unquote protective sort of filing, and it says aircraft location Camarillo Airport. She just put that in because...
This aircraft was clearly located in Camarillo up until it left in December of 2016.
Okay.
So it was definitely based out of Camarillo until it left in December of 2016. The question was it still based there January 1? That was the CITES hearing. My position is, regardless of how that case was determined, which it was determined in the favor of the assessor, I think it was a reasonable position to say that it was not located here. And Ms. Baladian is the one who signed it. You can see her signature. And she presented at the hearing and testified under oath, penalty of perjury, that she's basically doing their filings. She thought all the deadlines were May 7th, up against the deadline, and just filed it because she hadn't reviewed anything yet for them.
Okay. Thank you.
So on the on assessor's office or exhibit page 16, it's the application where you actually have it. It's stamped May 12th when they received it, and under the location it says Camarillo Airport, Air 7.
Yeah.
That is in May of 17.
Yes. Yes. So again, but this is all as of January 1, 2017. So you're reporting everything as of January 1, 2017, like where it was located.
But
Sorry.
If this was filed May 7th, 2017, and the plane left the hangar in December of 2016, you're stating that it was in Camarillo in May of 2017.
No, this form doesn't say that it was in Camarillo as of May of 17. This form would say it was in Camarillo as of January 1st of 2017, because you're reporting everything on these statements as of the lien date. Even though you're reporting it later, you're reporting it as of the lien date. Like if, for example, if the property had left in February, it obviously wouldn't have been there in May, but you'd still have to file this form and report it as of January 1st. And what Ms. Baladian testified was, because remember, she's the agent for the taxpayer, not the actual taxpayer. She was just filing all the documents. She thought all the deadlines were May 7th. She hadn't reviewed the flight logs for this aircraft, which had been historically located in Camarillo. And so she just filed what she termed a protective filing, because you can always just file an appeal later if you believe you actually were not located in the county, and that's what she did. She filed an appeal on the 2017 regular roll, stating that the aircraft was not located in Camarillo as of January 1, 17. So she was just viewing this as a protective appeal. And again, I'm just repeating what was given under oath at the last hearing.
Okay. Any other questions? Okay, I believe it's time for closing.
Can I just say one more thing?
Yes.
I guess I should reference. I didn't bring all the exhibits. There were all those binders because they said that those exhibits are still on the record. All the flight logs which show where it was were in the exhibits that were submitted at the CITES hearing, which is under the same appeal number. So they're all still in the record to review.
Okay.
Okay. Thank you.
We're all set with our questions. Now it's time for closing arguments. And I believe you get to present your closing arguments first.
You had mentioned you had some rebuttal.
I do have some rebuttal comments, but I don't know if you would prefer that we make them in closing.
To add on to that, as the assessor said, the burden shifts once the assessor proves they should have put the penalty. So now the applicant has the burden, and they have the right to close the hearing. Therefore, the assessor would present their closing statements first.
Okay.
So
You can just wrap them all into one if you want.
All right. that's fine.
Okay.
And you have documents to submit for this, or?
No.
Okay.
Just a response to the taxpayer's presentation.
Okay.
Do you mind if I just keep standing here?
No, that's fine.
Yeah, feel free. You can sit if you want to sit over on the stand. But yeah.
I think better on my feet.
Jacqueline Smith, Assistant County Counsel on behalf of the Assessor's Office. The flaw in the taxpayer's argument is that if they were going to make a protective filing, they could have done so on time. The documentation submitted by the assessor is clear as to when the filing deadline is. The letter that the taxpayer, or that Mr. Bladian referred to on page 13, says that there will be no grace period in terms of the response. That's in bold at the top of the letterhead, and that the due date for the form is printed on the aircraft property statement. This went to an attorney whose obligation it was to respond in timely fashion. And so if her strategy was to make a quote-unquote protective filing, she certainly could have done so by the deadline indicated on the form. The fact that she filed it on May 7th isn't explained by the fact that her strategy was to make a protective filing. If she thought there was some question or risk as to where this plane was situated and wanted to file a form protectively in case it was in fact situated here in Ventura County, she could have done that by the deadline. She may have come up with that strategy after the deadline, but that's not reasonable cause for filing this late. The taxpayer in this case filed taxes in Ventura County in 2016. Air 7 is headquartered in Ventura County. And so all of these excuses about what other counties are doing can easily be dismissed by the fact that this taxpayer has been filing taxes in this county before the May 1st, 2017 due date. We know they received the form on time. The letter is clear as to when the statement is due, and the simple fact is they filed it more than 3 months late. It's notable that the attorney who signed the form is not here in court today. For this board to find that there is reasonable cause and that there was not willful neglect depends upon her actions and her explanation for her actions. And she's not here to explain for your board why this form was filed late. And so if the taxpayer wants to make an argument that there was reasonable cause, surely the person whose error it was would appear before your board to explain themselves. But they're not here. And so this board should not go out on a limb for someone who cannot bother to appear before the board to defend themselves. I mean, I think the fact is the error is on the part of the attorney, and she's not here. She's not here to answer questions for your board. If your board wanted to know more about the reasons that this form was filed late, the attorney who's here in court today referred to her testimony before the Assessment Appeals Board in the CITUS hearing. And I would encourage your board to go back and review the statements that she made in that hearing, because what she testified to under oath is that the reason this form was filed late in May 2017 was because she was newly assigned to the client at the time of the deadline. And the assessor's office later connected the dots and realized that couldn't be the case because she submitted this property tax form for the same taxpayer in 2016. And so it is the assessor's position that she was dishonest to your board in that CITUS hearing about the reason for the late filing here. And there's a different explanation being presented today, which is this protective filing theory. And so for the fact that Ms. Bladian is not here to explain her error to the board, and the fact that the taxpayer was paying taxes in Ventura County prior to January 1st, 2017 and understood the rules in the past, nullifies any reasonable cause for this form being filed more than 3 months late in 2017. And we would submit on that.
Okay. Thank you. Any questions from the board? No. Okay. You can present your closing argument.
Sure. I want to clear up a couple things. One, the form wasn't sent to the attorney. If you look at the form's letter, it was sent to Air 7 LLC's Delaware Service of Process address. It was not sent to Ms. Baladian. Two, the assessor made some pretty cavalier comments about Ms. Baladian lying under oath. You know, just so you know, engagement agreements don't always last in perpetuity. So you can be engaged to file the 2016 filings and not engaged to file the 2017 filings. And then they can engage you right in May, who knows? So just to go out on a limb and say, oh, Ms. Baladian was lying without really reviewing all the facts is pretty reckless, in my opinion. The other thing is, let's not go for the red herring. We're not here to determine whether or not it was reasonable for Ms. Baladian to file it wrong. It's not the point. It's not even the argument I made. The argument that was made was it was reasonable not to file this form at all. We shouldn't be penalized because we were later filed in May. We should be no worse off had we, because we filed in May as opposed to not filing at all. The reasonableness is, was it reasonable to believe that the aircraft was not habitually situated in Ventura County as of the lien date? Because if you were not habitually situated as a lien date, even if you get this nice letter from Ventura, you have no filing requirement under the law. That's in Exhibit 1. You only have a filing requirement if your property is habitually situated in the county. So the question before this board was it reasonable to believe that there was no filing requirement? Whether or not there was any filing, was it reasonable to believe that there was no filing requirement because this aircraft left the county prior to January 1, 2017 and never returned? And it's not whether or not it was situated or not, it's whether it was reasonable to believe it was not situated in the county. That's the question before the board. And in my opinion, when you read Brock and your aircraft is not even located in the county and it never comes back to the county during the tax year, and it's not located in the county on the lien date and it never returns, it's not like this aircraft was gone December 29th and came back January 30th. It was gone. It left and never came back. That's the question before the board. So we don't need Ms. Baladian here to testify why she filed late or didn't file late. The question is whether there was reasonable cause to not file timely, and that is based upon whether it was reasonable or not for the taxpayer to assume they did not have a filing requirement because their property was not located in the county. And again, we're not here to go whether that's right or wrong. We're just here to say whether it's reasonable. And I think it's pretty reasonable for them to have that belief. And that's why we asked this board to abate the penalty for the 2017 tax year. Thank you.
May I briefly respond to that?
Yes.
This board found that the aircraft was habitually based in Ventura County. That's what the CITUS hearing was all about. And the taxpayer is attempting to relitigate that issue at this hearing to avoid the imposition of the penalty. But in terms of the interpretation of the penalty statute, this board has already made the determination that the aircraft was habitually based here for tax year 2017.
Okay.
I have a response to that.
Okay. This will be the last one then, okay?
Sure. We're not trying to relitigate the issue. One, we know the board found that. Two, we're still within the appeals period. This is probably going to go up to Superior Court. Two, it doesn't matter who's right or wrong. The county can be right on that issue, potentially, and there's still a reasonable belief that it was not CITUS here. So I'm not trying to relitigate the case. I'm not trying to get you to overturn the prior board findings. I'm just saying it was reasonable for the taxpayer to believe that they were not CITUS here. Again, not right or wrong, whether or not there was CITUS or not, just whether it was a reasonable belief that there was no CITUS. Thank you.
Okay, thank you. As a board, we'll deliberate on this behind closed doors, and we'll have our decision, I'm not sure what time today. We'll probably hear the other case first and then talk about both of them behind closed doors. So Mr. Vlahakis will inform you of our decision probably tomorrow or something like that.
That's fine. Thank you very much for your time.
Thank you very much.
Thank you.
All right, thank you. Okay, do we want to do like a quick 5-minute break to let everyone kind of switch around?
We're good when you are.
We good? Assessor's office, are you guys ready? It's there, they're talking. Okay, we are back in session. And we have one last case to hear. And who has the burden of proof on this one?
So,
We do.
Mr. Chair, first let me, as the parties discussed, there's a request for continuance by the assessor, which the applicant objects to. We've provided your board copies of the applications for the various properties. And additionally, attached to that is copies of a Revenue and Taxation Code Section 1606, Exchange of Information, initiated by the applicant's representative, Mr. Nichols, who's here today. So he initiated that timely on September 5th, 2019. And then the assessor had until 15 days before the hearing to respond to that, which they timely responded on September 19th, 2019. So those documents there have been provided to show that the parties have both timely entered into an exchange of information. You've also been provided an overview of the rules related to 1606. It covers what's required to be exchanged in advance by the deadlines. And then because a continuance is requested, there are some restrictions on when a continuance may be granted. As highlighted in Property Tax Rule 305.1, the parties may introduce evidence that wasn't exchanged if the other party consents, and if the other party consents, then they shall be granted a continuance. So in this case, the assessor has mentioned new evidence has been submitted. If that is submitted and the assessor consents to that, a continuance is required. If the applicant does not submit the new evidence into the record, there's no dispute over new evidence. Also in question is 441H. If the taxpayer fails to provide the assessor evidence and then presents it at the hearing, the assessor shall be granted a continuance. To highlight there, it says if the materials are presented at the hearing. So again, a lot of this is going to depend on what the applicant presents to you today, and that is the overview of the issue here. And then possibly we want to hear more from the assessor on why they're requesting a continuance.
Okay. Comments from the assessor? Comments from the assessor's office?
Yes. Christopher Horn for the assessor's office again. We received information that we had previously requested under 441. This information was received on Friday.
Okay.
And
when was the deadline for receiving this? 2 weeks ago?
well, at minimum.
Yeah. Okay.
So we're still trudging through that information and comparing what was sent on Friday to what was sent under the 1606 that Mr. Nichols initiated. Also, on our response, the assessor clearly states down at the bottom on page 2, note, the assessor is reserving the right to finalize its value at a later date as additional information is still outstanding from the Revenue and Taxation Code 441D requests. That's the reason we're asking for a continuance.
Okay. That makes sense.
May I respond?
Yes.
So the information they wanted was not part of my case in chief. It would basically be rebuttal information to whatever they're going to present. And one of the things they asked for was balance sheets. In all my years of doing valuations of golf courses and other things, I've never been asked once for a balance sheet to value a real property rights of an operation. So I sent it to them. However, it's germane or it's immaterial to the valuation of this as facts. There was some information regarding renovation. I did send them that, but that's not part of our case in chief, and it has nothing to do with the real property rights and the ultimate fair market value of the property, and I'm prepared to go forward.
Okay.
So basically, they're asking for information that's immaterial, that even if they had it earlier, I wouldn't present and probably wouldn't matter at all to this board or this case.
Okay. Assessor's office, is this information that is relevant? The balance sheet?
How do I can't tell you what's relevant and what isn't, because we're still digging through it.
Okay, understood. Any comments from the board or council? It kind of looks like we're going to have to continue this. Because
I would just say that the assessor's already been granted their continuance once already, and we're prepared to go forward.
Okay.
If a continuance is granted, then I would ask for special hearing to have, because I have another golf course case coming up, to have both of them calendared at the same day possible, as well as on this assessor 1606 response. They've given a cap rate range in some of their market data, but they haven't provided me the comps to verify those cap rate data.
Okay.
So that under the 1606 exchange, if you're going to provide cap rate data, the whole point of the 1606 exchange is so I have the time and the ability to research the data that we're providing. By giving a cap rate range of 7 to 14, I don't know how they're obtaining that data. So if the continuance is going to be granted, I would like a special request by this board for the assessor to turn over their actual cap rate data, their discount rate data, their net income rate data, and their DCF assumptions so that I have an opportunity to rebut it as well.
Okay. Brandon, is the other golf course date on the calendar?
I think it's come up.
October 28th. I don't know. With the hearings lately, we don't know what really is going to go forward until the week before. Originally, we had a couple hundred on today's, and as you see, we've whittled that down to 2 and possibly only 1 moving forward. So we could have time on the 28th. We might not.
Will that be enough time?
How about this? I'm fine to maybe calendar this to like January, as long as the hearing on the October 28th, that gets moved to the date that we have the Sherwood, which I can, if the assessor, would you object to that?
Yeah, that's fine.
Okay.
We can do January. And as Mr. Nichols is requesting information from us, in talking to the assigned appraiser for the case on the 28th, I believe there's still some outstanding data for that one.
Okay.
If we move both of those to whatever January date, then I think both sides can also agree to get the other information within the next 30 days.
Okay, so what date are we looking at there, Brandon?
So, I don't know. If we do January, the 6th is right after the holiday. We don't typically do holidays the week after, hearings the week after a holiday because no one will be working on the Wednesday. You already have a special hearing on the 13th for a department store. The 20th is another holiday. The 27th would be right back to back with a hearing officer. I guess we could do a special hearing on the 27th, and Mr. Crow would just be here 2 days in a row for hearings. Any other day of the week, I'd have to do further research on availability of the boardroom and board. Also, it's going to be you three regardless because we're now short on board members, so all 3 of you would have to be available January 27th or whatever date we choose. So unless we go to existing date that we already have.
I'm fine with the 27th.
I could do the 27th. Those dates in February look a little bit, well, I can't commit to those because there's some holidays in there. I could do the 27th.
Mr. Crow, are you okay with
Mr. Crow, are you okay
doing
being
hearing
2 days in a row?
officer?
27th and 28th? Yeah, and you're also in 28th for a hearing officer. So you're okay 2 days in a row? All right. Assessor's office, is that okay? Okay,
January 27th works for the assessor's office.
okay. So we're looking for a motion to continue to January 27th with the proviso that both sides exchange data required within 30 days of the date. Or do you want me to make it 40?
No, how about 30 days of today?
30 day, within 30 days of today, that both parties exchange the data that they requested.
So, Mr. Nichols, have you put your request to the assessor in writing detailing the things you mentioned on the record that you need, or is that the first time you've detailed it out?
No, this is the first time I've detailed it out.
Okay, so I don't know if you want to restrict it to what his oral testimony is, or if you want to ask that he put it in writing, versus with the assessor, we'll have it in writing to verify what was requested. And Mr. Nichols will just have it on the verbal record so far. So I don't know if you need any.
Mr. Nichols, would you be willing to email the assigned appraiser what you would like, the information you request, and this will, instead of the board finalizing what we need to provide you, this will give you possibly a little bit more time to.
I have no problem with I just want to make sure that you're put on record that you understand what I'm asking for and you don't try to, no funny games.
Moi? No, no funny games.
Okay.
Okay, looking for a motion to postpone to the 27th with the proviso that within the next 30 days, both parties exchange the data requested.
Which they will do via email.
Which they will do via email.
So moved.
Thank you.
Thank you.
Right, and please vote on that. Okay, so that passes. I just want to make sure I have a clear understanding of what is happening with the other golf course case, which is not on today's agenda, so the board can't really take any action on it, but it's everyone's intent to have the second golf course also on the 27th. Is that correct?
That's correct.
Okay, and Mr. Nichols, you still maintain your right to postponement on that until 5 p.m. today, so do you want to just take care of that with your postponement, right? And we'll move it to the 27th, and then you're all squared away. Otherwise, it's going to require a mutual agreement signed between you and the assessor. So
That's fine. Do you need it in writing or will verbal work?
your verbal confirmation is fine. I'll process it tonight, and we'll move the second golf course using your postponement right to January 27th.
Thank you.
Okay, that wraps it up. Your board has no other business for today.
Okay, we will deliberate behind closed sessions on the first case, and we are adjourned.